Good afternoon. My name is Cynthia Marwood and I'm the CEO of the Sentencing Advisory Council. On behalf of the Council, thank you for making the time today to attend our Law Week event, where we will be exploring the results of recent research looking at the views of jurors on the sentencing of sex offenders. I'd like to begin by acknowledging the traditional owners and custodians of the land on which I'm working, the Wurundjeri people of the Kulin Nation, and I pay my respects to their elders past, present, and emerging. Our guest panelists today are the Council's Chair, Emeritus Professor Arie Freiberg, and Her Excellency, Professor the Honourable Kate Warner, both recognised sentencing experts. Professor Warner has been the Chief Investigator of 3 separate jury projects: the Tasmanian Jury Study, the Victorian Jury Study, and most recently the National Study. These studies build on each other and focus on different questions, but each shares a focus on gauging the views of jurors on sentencing. Today, our panelists are going to focus on the results of the National Study. We expect the discussion today to go for approximately 45 minutes and finish at 2 p.m. There will be time at the end for Professors Freiberg and Warner to take some questions, so please don't hesitate to use the Q&A function throughout the session to pose any questions you have, and we'll try to get to as many as we can at the end. We will be recording the session today and we'll post it on the Council's YouTube channel should you wish to watch it again. Now I'm going to hand over to Professor Freiberg and the Honourable Kate Warner, who will discuss the findings of her research. Thank you.
Thank you, Cynthia, and thank you all for attending and participating soon. And thank you, Your Excellency, in a busy time in Tasmania, a minor matter of an election to deal with, but we know that sentencing is far more important, and it's a great honour and a pleasure to have this conversation with you and be able to shed some light on sentencing and have our audience participate in this discussion later on. So these jury studies are part of a wider enterprise to look at public opinion, to look at it through surveys, look at it through questionnaires and the like. So I can ask you a fundamental question. Why is public opinion relevant? What's that got to do with sentencing anyway? Why should judges care? Why should politicians care? Why should the media care? Surely this is a job for experts.
It is, but nevertheless, judges and politicians too, but judges are very concerned about public confidence in the criminal justice system. And so it's thought that if the public lack confidence in the criminal justice system, that it's possible that they'll be less likely to cooperate with it. So they may be less likely to report offences, less likely to cooperate by giving evidence in court, less likely to be a juror, less likely to be willing to perform jury service. But as well, it's thought that if there's a real loss of confidence in the criminal justice system, then there may be less compliance as well. And of course, that's important. So for those reasons, I think there is always concern that there is reasonable confidence in the criminal justice system, and confidence in sentencing is certainly an important part of that, probably because it's such a visible part of the system.
So I understand why politicians might be interested, given they have to be elected and need to know that you get the pulse of the populace. But what about the judges? Should they take it into account, do you think?
Well, I mean, they do care about confidence in the system and people complying with it, and also cooperating by reporting crimes. And I mean, it's generally thought that they shouldn't disregard public opinion. So they couldn't actually, they shouldn't respond to public clamour for a severe sentence in a particular case. But generally speaking, they should be aware of public sentiment. So they should be responsive in that kind of way.
So the challenge is to find out what public sentiment or public attitudes are, or public opinion. And that's quite difficult. So there've been lots of projects in the past that are surveys and the like, but tell us what some of the projects that you've been involved in, particularly in Tasmania and Victoria and the National Study.
Yes, well, it's really a different approach. And we had the idea of doing this because a Chief Justice of the High Court thought it would be good if we asked jurors what they thought about sentencing. And this was because they've actually had the experience of a real trial. so they'd be well informed. So rather than just asking members of the public who may not know much about sentencing, to ask a juror about a sentence in a particular case that they've been involved with seemed like a good idea to get a more informed response.
So the general public opinion surveys go out and ask 1,000 people or so to get a good statistical sample. Do you think juries are representative of the public?
Well, we looked at that. We've had large groups of jurors now. So in the national study, we had some 989 jurors responding. And we looked at the background of these jurors and compared it with statistics about representativeness. And we did find that our jurors were quite representative of the public. They are a little more educated than the general public, but not a lot. We were overrepresented in the 20 to 55 age group, and we had rather more men than women. But generally speaking, they were quite representative.
So you feel reasonably confident that the feedback from them was reflective of the broader community. So tell us, you've done two, one in Tasmania, that was the pioneer one, another big one in Victoria. Tell us about the national survey. What's that about?
So, well, the national survey, again, we adopted the same kind of approach that we did in the earlier studies. And the basic idea was to wait until there was a guilty verdict in a trial, and then to ask the jurors what they thought the sentence should be for that particular offender. And so we did this obviously after the guilty verdict, but before they knew what the sentence was. So our first question in all of these surveys has been, what sentence do you think should be imposed on this particular offender? What do you think particularly? Not try to guess what the judge will do, but what do you think? And so that was the basic idea. And then after the sentence was actually handed down by the judge, we would then send the jurors a copy of the sentencing remarks, which would contain the sentence and the reasons. And then we'd ask them what they thought about the sentence, as well as asking other questions too.
So
basic idea, Arie.
That was a bit of an iterative process that had some information that had the advantage of sitting through a trial, and then you provided them, so they didn't come to it completely cold. The focus of the national study, unlike some of the other studies, was on sex offences. Why focus on those offences?
Well, we decided to focus on sex offences because these seem to be the offences that most concern the community, the ones that they're most worried about, and the ones where they tend to suggest that sentences are too lenient. So when you ask members of the public just that general question, are sentences too lenient? When you ask it in relation to sex offences, they're more likely to say that sentences are much too lenient. So we thought it would be good to focus on sex offences and to see if there were differences between kinds of sex offences, as well as comparing sex offences with serious violent offences, another area of concern.
So these are sort of a flashpoint, aren't they? They are the ones that evoke concern and emotion in the public, especially when we have read about the Royal Commission into Institutional Child Sexual Abuse and those cases which really upset people, and where the evidence is there's probably a greater disparity between what the public thinks and what the court thinks. So what did you find in this study, or what are you finding in this study?
Well, we found that jurors still were more likely to suggest a more lenient sentence than the judge, than select a more severe one. So the national study had sex offences and also some serious violent offences, and we found that 62% of the jurors suggested a sentence which was the same or more lenient than the judge's sentence. And when we looked at the difference between sex offence trials and serious violence, it was still 60% in sex offence trials, 60% of jurors coming up with a sentence which was the same or more lenient than the judge's sentence. So this, in a way, was quite surprising.
Now, why do you think people think that judges are soft on crime when the people who are notionally in the room or in the jury room and then afterwards come up with substantially similar findings about the sentence? So what is it about the general perception that judges are soft on crime, that people walk free? Why does the public have that perception? Why is it so different in these individual cases?
Yes, this is a really difficult question to answer, but there certainly is a difference between response to that general abstract question and the response to the individual case. So it must be something to do with the humanising effect of seeing an offender in the flesh, actually knowing much more about the particular offence than just being asked that general abstract question. So there are lots of theories of why this is the case. People say that it's a different kind of thinking that happens with those different questions. So particularly, one of the answers is that the public aren't really well informed about what sentencing levels are. So we tested that too. So we wanted to find out, well, what do the public actually know about sentencing levels? And in the national study, we found that very few offenders really knew how severe sentencing was. So they tend to underestimate it. So we asked them questions about the proportion of offenders who are sent to prison for a serious sex offence like rape, and only 20% of jurors got this right. So they really do underestimate the severity of sentencing. And we found this too with our jurors. They'd be surprised when they actually heard what the sentence was. So they expected that the judge would impose a sentence which was more lenient than their sentence. And yes, they would be surprised by the actual sentence. So that's part of the answer.
So the reality and the theory are quite different in terms of once people know more about what the sentence is about and the sentencing process and the options, the closer they are to what the actual outcome is. So in terms of in sentencing, we know there's the gravity of the offence and people know about how serious sex offences are, but there are aggravating and mitigating factors in any situation, aggravating factors like prior convictions or mitigating factors such as youth or mental disorder. What did the jurors and judges think were the most important aggravating and mitigating factors in your study?
Well, it was really interesting comparing the judges and the jurors in this respect. And we found that really there was a lot of agreement between judges and jurors. So both judges and jurors gave much more weight to aggravating factors than mitigating factors. And that was a common thing for both groups. And we also found too that for aggravating factors, they really agreed on the most serious aggravating factors or the most important ones. So both jurors and judges thought breach of trust was really important, emotional harm to victims, and also victim vulnerability. So they all agreed that those were they were the most important aggravating factors. But we did find some differences, and one was that in relation to prior convictions, jurors thought this was more important than judges. So they tended to give more weight to prior convictions than judges did. And also with mitigating factors, there were similarities. And we were a little bit surprised actually to find that jurors actually were more likely to give a lot of weight to some of the mitigating factors, such as mental disorder and old age. Yes, those two factors, and also social disadvantage. So for those three factors, the jurors were more likely to give that particular factor a lot of weight. But there are other factors that jurors gave more weight to, or judges gave more weight to than jurors, and good character was one. So yes, jurors were less impressed with that as a factor. And also they were less impressed with a plea of guilty as a mitigating factor.
which is a major factor that judges are required to take into account by legislation in Australia.
Absolutely, yes. And often, yes, and to give quite a significant discount. So because we were dealing with trials, obviously we weren't dealing with pleas of guilty, but we did ask our jurors what sentence they would have imposed if the offender had pleaded guilty to the offence rather than going to trial. And we found that only 25% were willing to give a discount for a plea of guilty. And they were more likely to want to increase the sentence because the offender pleaded not guilty. So they like to look at it that way, whereas the law looks at it differently. We don't regard a not guilty plea as being aggravating, but we do regard a plea of guilty as mitigating. So there was a difference.
So that raises the question, so what policy implications should judges take into account what jurors think, or should jurors be educated as to what the law is? Because if we didn't encourage guilty pleas, for example, then the courts might be overwhelmed with far too many cases and we would have huge delays. So what do you make of those findings in terms of everyday practice?
I think that we should think of, well, what can we do about this? And for sometimes when there's a difference, I think we can change the law. But in relation to this, I really think that we need to keep the discount, is my view. But I think really judges need to make more effort to explain why it is important that we have a discount for a guilty plea. And you think, you know, in sex offence cases, it's really tough on the victim going to trial, being cross-examined, recounting the facts of the offence. So I think that if jurors really appreciated that and that was explained to them, then I think, well, not members of the public, I think that would maybe help if there was a better understanding of the advantages to the victim of a guilty plea.
So community education seems to be reasonably important in this to, in a sense, enhance or maintain or create public confidence in the sentencing system and the criminal justice system generally. Do you?
I think that's right. And I just going back to the guilty plea for a minute, I think it does tell us that we have to be careful about not having a huge discount. And as we know, there are differences between jurisdictions. Some jurisdictions have really allowed quite a massive discount, greater than in others. So I think it shows that perhaps we should be cautious about this, that we don't want to lose the trust of the public. So that's an area where I think, you know, we can say, let's heed what the public say about this and not overdo the discount.
Your Excellency, you've written many articles and books and you've spoken publicly. What do you think is the best way to communicate to the public, to the community who have an interest in the criminal justice system about the operation of the system and sentencing in particular? What do you think are the best mechanisms? And do you think that's an important role for governments or other bodies?
Yes, I think it's very important. And it's, of course, one of the things that the Sentencing Advisory Council does. But I think that judges can have a role here as well. And I would like to see them make their sentencing reasons more accessible. In some jurisdictions, they're enormously long and they're not necessarily having the public in mind. I think they need to be, you know, more concisely explained. And rather than using legal jargon or just referring to something without explaining it, I think that would help. And I do think that I know that our jurors really appreciated getting the sentencing remarks and reading them. So I think to make them more accessible would be a really good idea. And then, you know, the media too, it would be easier for the media too to discuss a case. But certainly if you could go online and easily access sentencing remarks, I think that would be a good idea. And if they maybe had a little summary with them too. I know this is more work for judges, but I do think that that would be useful because we found that our jurors really did like to receive the remarks and, you know, were interested to read them. And I think that would help. That's one of the ways.
You talked about the general public. So jurors are a small subset because they've been involved in offenders and victims and judges. They're all a relatively small proportion of the population. You mentioned the media and I know this is a very controversial area, but most people in the community get their information from either the broadcast media, from newspapers, and these days even more so on social media, which has got a wide field. So do you think there's a role for, or what role do you think the media or social media can play in providing information to the broader community, not the populations that we're talking about, jurors,
Yes.
victims,
No.
offenders?
Yes. No, I think that there is a role there, and I know courts are now getting media officers and trying to engage the public in this way. So I think that if, you know, they can engage the public through social media and also provide a link through to the detail of the sentencing remarks, I think that would be useful. If people knew that they'd heard about a case in the press and that they could actually find out more accessible information about that case, I think that would be useful. Yes.
It's a common criticism that you hear again and again. The judges are out of touch with the community. They are elitist. They come from private schools. They don't live in the same world as we do. Do you think jurors believe that they were out of touch with the community? And if they're out of touch, who is in touch with the community?
Yes, that's a good question. We did ask jurors about whether they thought the judge was in touch. And we had a question that says judges are in touch with what ordinary people think. And jurors were invited to say whether they agreed with that or disagreed with that. And we found that only 25%, only a quarter of jurors disagreed with that. So they were, in other words, saying that judges were out of touch. And this was a big contrast between the same question that was asked in a national survey of the general public. So in that survey, a majority of people disagreed with the statement and said judges were not in touch with what ordinary people think. So having jurors who actually sat through a trial got quite a different response. So that's interesting, I think, that when people know more about the system, they think that judges are more in touch than if they don't. And the jurors tended to be quite complimentary of their particular judge. So we found that even if they said judges are out of touch, they said, but no, not my judge. My judge was great. And that, yes, was a very consistent response.
So we should have people sitting in court all the time.
We should, and yes, and that clearly is not at all possible, but there is a difference. But I think because jurors have had this experience, then maybe we should take some note of what they say.
If it's thought that judges get it wrong some of the time, or all the time, according to some reports, then who do they think is the best person to impose a sentence? Would they like a role in it, or Parliament? I mean, who do they think can get it right, or righter, or better?
Yeah. Well, again, this was an area where we had a big contrast between what jurors thought and what other members of the public thought. So we had a question which said judges are the most appropriate person to choose a sentence in a particular case. And the majority, something like 75% of jurors agreed that the judge was the most appropriate person. But when we asked the same question to an online sample who hadn't been on a case, they thought that the judge wasn't the most appropriate person to hear the case. And we also asked jurors whether they'd like to be involved in deciding the sentence themselves. And they did not want to be involved. They didn't want that responsibility. They'd had the responsibility of reaching a verdict, and they felt that was enough. At most, they would have liked to ask the judge to consider certain factors, but they didn't want to be the person who actually, or the group that decided on the sentence. So, they were very happy to leave it to the judge, which is interesting.
It is interesting because it is a very onerous role, and I think jurors realise that now. Putting a plug in for the Victorian Sentencing Advisory Council and the Queensland one and others elsewhere, we do run a You Be the Judge on video that people who attend here and others can use and have a go at being a judge themselves and then compare themselves to others. But it is difficult, and we do get a wide disparity. But I know in other studies that you've been involved in with others that if you ask them, do you want to be the judge? They generally say, no, thanks.
They say, absolutely, they say no thanks. And we've asked them about discretion as well, because, yes.
Because discretion is really central, and one of the things that happens when people think that judges get it wrong is the call for mandatory sentencing. This is a very popular response to beliefs that judges get it wrong, and so Parliament steps in and reduces the judge's discretion. What are your findings on the jurors' views about whether judges have too much or too little discretion?
Well, we found that our jurors, something like 82%, thought that judges had the right amount of discretion. They didn't think that they had too much. Yes, and so similarly in earlier studies, we focused on mandatory sentencing and asked them about that. And there was not support for mandatory sentencing, only minority support from jurors. So they seem to be happy, you know, with the system as it is in terms of the amount of discretion.
And that runs very much counter to the politicians' appeal when things go terribly wrong, or when they think things go wrong, that the result is mandatory minimum sentences, mandatory sentences, lock them up and throw away the key. All of those responses are there. But what you're saying is that that doesn't really reflect the reality of public opinion, if the jurors do indeed represent them, about judicial discretion and its role. Is that a fair?
That's right, yes. So I think, you know, these jurors have sat through a trial. They say a real offender. And certainly when they get the sentencing remarks, they learn something about the background of the offender, as well as knowing a lot about the facts of the case. And they have a different view of it. They realise that, you know, sentencing is much more complex than it appears at first sight. It's not something that you can just decide in advance with a mandatory penalty. So I think that it makes a huge difference.
So we're going to come to questions. We've got 3 questions from the viewers, the audience, and we do invite you to type in your questions. They're terrific questions so far, and we'll get Her Excellency to answer those. But the question about the difficulties of understanding discretion, difficulties of understanding public opinion, all these are central to your inquiries, aren't they? And if you wanted to summarise very briefly what the Tasmanian studies, the Victorian studies and the national studies tell us about the relationship between public attitudes, public opinions and sentencing, what would you say was the most important outcome of these studies?
I think they're really telling us that when you have a member of the public who is informed about a particular case, that they tend to endorse the views of judges and that they're not clamouring for heavier sentences in accordance with this measure. So I think it's telling us that it's not a good idea to just rely upon responses to that general question. Do you think sentences are too lenient? Because you're really not getting an informed response there. So I think that asking about a particular case is a much better way of trying to gauge public opinion.
That's terrific. It's very important. And congratulations on all your work, and this is really pioneering work.
All right. Thank you, both of you, for your discussion of the results of Kate's study. Now, would you like to just would you like me to read out the questions to you? Coming from our audience?
Perhaps I'll do that since you've got some background noise there. So perhaps, Kate, I don't know whether you can see them on the screen.
No, I can't see.
I'll read them out to you. So our first question is, what do you think about the sex offenders' rehabilitation after completion of their imprisonment?
Yes. Well, all in favour of sex offender rehabilitation. And I think there should be as many opportunities for that as possible. I really do think that just punishing the offender without making any efforts towards rehabilitation is not a good idea. And it's good to see that there are more sex offender rehabilitation programs being used in most jurisdictions. And I do think that's important, rather than just releasing the offender.
And the evidence is, I understand, that the recidivism rates, much to the contrary of public opinion, it's not 100% for all sex offences and sex offenders.
No, it certainly isn't. It isn't. So again, that's another mistake or error that the public make. They tend to really overestimate the recidivism rate of sex offenders.
Indeed, and there is evidence that well-targeted, properly evidenced interventions and programs can be effective.
Yes, there is that evidence.
So we have you might find this possibly a little cynical from our next questioner, but he or she says, do you think the media will begin to report more accurately or fully on sentencing if the courts try to engage with the media more? Or do you think that the media's financial interests, which are supported by sensationalist articles, which sell papers and get clicks, will always win out? Now, there's somebody who's been around a long time.
I think so. And I think there's some truth in that. I think you have to be careful about which media you actually read or listen to. So no doubt, I think the media will always try to sensationalise offences, to sell papers, to sell their product. And that is a difficulty.
It is. And we know the power of the media, although it's becoming more dispersed with social media, Twitter, Facebook and the like. So not as central as it used to be, but the media, the traditional media, mainstream media, has still set the agenda for many of the debates of the day on the radio and the like. Our next question. Yes, sorry.
Oh, I was just going to say that we just had a recent murder case, murder trial in Tasmania, and it's been reported by the media quite widely. And it was an unusual story that the victim's mother said that she, in her victim impact statement, that she forgave the offender. And that is quite unusual for the media to actually highlight that. And I thought that was, a bit of a change in story, rather than outrage and, wanting a really severe sanction. Indeed.
Another question says, and points to a very, very tragic case of a sitting magistrate who committed suicide after critical and sensational news reports regarding sentencing. Yes. I think I knew that magistrate personally. It was a very tragic case. The question is, do you think it's possible to hold news outlets accountable for such news reports? Because perception is what's driving public opinion, which is informed by news reports.
Yes. Yes. So, again, I don't know what kind of response the media who hounded that particular magistrate, I don't know what their response was, but one would hope that it would make them think twice about that. I know that in some countries, in Britain for a while, there was a lot of publicity given, the press would single out certain judges to be particularly critical of their so-called lenient sentences. And we also had a Queensland judge who was very much criticised for her lenient sentences too, which was very difficult for that particular judicial officer. Mm. So, I guess it's, it's one of the hazards of the job in a way.
In the olden days, you and I remember them well.
Yes.
The cases were not available. Sentencing remarks were not available. You had to go to the law libraries, and sentencing remarks were not reported basically anywhere other than appeal courts and in a sort of wonderful bookshelves like behind you and me. Yes. There, but the members of the public, jurors, would not have access to them. The question now is, in the world now where we have resources like Ostly, which are open and free, which is where cases are provided. Not all sentencing remarks. Certainly in Victoria, I know county court remarks are there. Supreme Court,
yes.
There's audio presentation, sometimes video. Are jurors told or aware that they can look at cases and sentencing remarks on Austlii at no cost? How do we get that information out to the public?
Yes, I don't think they are aware. And of course, even though it's just the juror, and that's quite a small group, they do discuss the case with their friends. I mean, they're not allowed to discuss the deliberations, but they can discuss, you know, the evidence and the sentence. So yes, it would be good to get that out and to make sure jurors are really aware that they can access that knowledge. But I think another factor is that in these days, they say there's less trust in the experts. So once people were happy to leave the sentencing to the judges and experts and assume that, you know, they would more or less get it right. But now the public do want more say in these things. They want to be more involved. And so, I mean, that has, one of the things is that it means that there's more criticism of experts.
We have a teacher out at Sandringham Secondary College who says, what information can you provide him or her to provide to the students how your studies, and there are many of them, I think there are 20 or 30 publications now coming out of these various studies, how do they fit into the sentencing reform process? That may be an exam question, I don't know.
Yes.
How do you think that translates into criminal law reform?
Yes. So I think it would be great if legal studies students and so on could access our papers. There are some shorter ones, aren't there, Arie, which are particularly in the Alternative Law Journal, which are more accessible. But if you go onto the University of Tasmania website and under the Faculty of Law, under the particular, under research, you will find that you can access information about the jury projects, and all of the articles are there, they're listed. So that would be one way of accessing the information about these particular studies.
So helping the community understand is really important, and the Sentencing Advisory Councils of Victoria and Tasmania have numerous studies, and the Victorian website of our council has a summary of many of the studies, so that's easily accessible if you can't get the original documents.
Yes.
One of the questions is, when you asked the jury after a finding of guilt, were they told the maximum penalty and what was expected to be the sentence? I'm not sure about the second part there, but were they told what the maximum penalty was?
No, we didn't tell them anything. We just said, we want you to say what you think this sentence should be in this particular case. And it wasn't until stage 2, when we sent them the sentencing remarks, that we gave them some information about the maximum penalty and the usual range of penalties for that particular offence. We provided them with that as well.
Do jurors get any information about the criminal justice system before they're part of a jury? What are they told? Because sentencing is not their job, but are they given a briefing?
Not about sentencing at that stage.
Right.
No, they are given information about their role, but they're not told about sentencing before the trial. And in fact, sometimes jurors do like to know before they reach their verdict, what is the likely sentence if we convict? And if they ask the judge that during their deliberations, they're told, no, you don't think about that. That's not your role. We just want you to come up with a verdict.
But in your studies, as you went through them, you then provided them with more information. In some of the studies, you provide them with a fact sheet, background, statistics. Was that important?
Yes, very important, because then we wanted to ask them whether or not they thought the sentence was appropriate. So by giving them a little sentencing booklet, information about the usual range of penalties for that particular offence, we wanted a more informed response about how appropriate the penalty was. And we found that at stage 2, 85% said the sentence was appropriate, and more than 55% said it was very appropriate. So, you know, they were happy with the sentence. Most of them were happy with the sentence.
That's very important. Sex offences are really problematic these days in the sense that a lot more people are coming forward to report historical sex offences. And the Royal Commission found that the average time between the offences being committed and reporting was about 30 years. So that's an extraordinary time. The question is, do you think that sentences change based on whether the offending happened recently or whether it was historical? Should they be either way?
Yes, now that is a very good question. So I think, and the law has often had different responses to that in different jurisdictions. And we've asked jurors too what they thought about delay as a factor. And it was interesting to hear their response. They weren't so sympathetic about delay. They didn't necessarily think that because it was a long time ago that the penalty should be less. They said, well, the offender's had all of this time without being prosecuted. So, you know, that should be an advantage.
Indeed, but the law is quite mixed on this, and it's a really difficult jurisprudential and philosophical issue, especially when 20 or 30 years have passed, and the offender, of course, will be a much older offender. They might be in their 70s or 80s, and there are health issues, and there are other issues involved about keeping elderly people in custody. I do foretell that the Victorian Council will be soon publishing a report on sentencing older offenders where some of these issues are covered.
Yes.
One or two more questions, Kate. This one is probably someone who believes strongly in artificial intelligence or computer-assisted decision-making. Why, they ask, is a discretionary model on sentencing favoured as opposed to a more formulaic or algorithmic model? Let's go for the computer. Computer says 5.
Yes.
Excuse me.
I think it's because, I mean, judges always say every case is different, but I think jurors are inclined to think, well, you do need to have discretion to cope with the differences between cases. And I think that our jurors, when they're asked the specific question, don't rely on stereotypes. They look at the offender, the facts in relation to the offence, and also the facts in relation to the offender. And they seem quite content with judges having a discretion to make a decision rather than having some kind of computerised model. That's not to say that judges shouldn't have guidance, and I think both Arie and I quite like the idea of guideline judgments with some quantitative indicators in them to get consistency, to get more consistency. But that again is, yes, that's
one of the fundamental issues.
Yes.
Well, we've come to the end of our time, our allotted time. I do want to thank you on behalf of the council and those people who've participated for giving up your really valuable time in your high office, and we do wish you well with your further studies and the publications. They've been a very important part of the Australian criminological and sentencing landscape, and we've certainly learnt a lot about sentencing and the public's views of sentencing and how important they are to the criminal justice system. This discussion has been recorded and will be available on YouTube. Cynthia, do you want to make some final observations?
Just to thank you both for your participation in our Law Week event today, and also to thank our audience for coming along, and to remind them that they're also welcome to come along to our second Law Week event this Sunday, where we will invite them to step into the shoes of a judge or magistrate and sentence Michael, a man with a complex history who has been found guilty of armed robbery. So I wish everyone a great weekend, and thank you for your time today.
Thank you for inviting me to be part of this. I've enjoyed it.